please come to my lord. 18.
This will apply to all categories of minerals.
No.
Why?
No, but for minor minerals, all major minerals, yes.
That's right.
Yes,
It applies to all minerals.
Yes.
All minerals.
Except
In
minor.
fact, chapter 2 also applies to all minerals.
Yes,
Only rule making power is left to the state government under Rule 15.
No. I'm sorry.
Rule making power in respect of minor minerals is left to the state government.
For minor minerals, yes.
But all other provisions apply to both the categories of minerals. They apply generally to
Correct. But
because I was just looking at
but
the definition of
30
the expression minerals. It covers all minerals. Minerals includes all minerals.
Correct.
Except mineral oils. So it's not that minerals includes all minerals except minor minerals.
I'll invite
Minerals includes all minerals.
all minerals. But for rule making power,
State can make rules under section 15.
for minor
minerals.
But
Not only
13.
Not only that, under section 14, it categorically says.
Exactly,
that
I was coming to
5
14. I'm obliged.
they do not apply to minor
Only
minerals.
4
Yes.
applies. Only 4
The
applies.
provisions of section 5 to 13 shall not apply to quarry leases, mining leases, or other mineral concession in respect of minor minerals. These sections are not applicable.
4 is applicable.
And
4 is applicable.
yes, 4 is applicable. But the rules will be made, who will grant lease, how to grant lease, what will be the royalty, what will be the fee. But my lord, according to my respectful submission, 13I is an all-inclusive provision which can be subjected to levy. My lord, it can be fixing and collection of fees for mineral concession, surface rent, security deposit, fines, other fees or charges, and the time within which the manner in which the dead rent or royalty shall be paid. This is a statutory provision to be made by the central government in exercise of its statutory rule-making power. Now, please come to 18. I'll just show the title, Manoj.
And only one thing. You go to section 15.
Yes,
Similar power is conferred on the state also, rule making power.
correct. Manoj, for minor minerals. No, notes.
For royalty, etc. also.
Yes, Manoj. Correct, Manoj. So, for Manoj, that's what I was submitting. The legislature was dealing with 2 categories of minerals.
So, therefore, if you see clause number G, it authorizes state to frame rules for even collection of royalty.
Correct, it's correct. But for minor minerals,
For minor minerals, yes, but
No,
that power is conferred.
I'm saying the same thing, that there are 2 minerals, major and minor. For major, the center retain its control. For minor, it is delegated to states except these 5 sections under section 4. These rules for minor minerals, the parliament acquires and then delegates to the state. That's all I am saying. Major minerals, only central government and only I. These are the entries, which it closes. It's all inclusive entries. This is all you can provide for and you can charge. Now, your lordships may kindly come to 18, just the title, Development of Minerals.
How do we reconcile your argument with the debates in the Constitution Assembly when they decided that it should be kept, this power of taxation should be kept with the states?
No, not really. I have the debates also, in my note.
That it should be brought in the union list.
Yes.
They specifically said that it should be kept in the state.
Yes, but subject to, union prohibiting it. Correct, but I am not.
No, by your argument, this particular act, this is the only act, Parliament, this is the only act.
Yes, yes.
Now, this act, it talks about very many things. And in case of minor minerals, it talks about what is being given, so far as minor minerals concerned, the power to the state. It could have also said that the power of taxation for minor minerals is given. It's not said so.
Maybe that is derived from 50.
We have to see why it is not said so. The parliament.
50 because of 50. They would tax under 50 because
So therefore, the power to tax.
allow me to answer. No, my lord. Allow me to answer.
Ah.
That exactly, my lord. That's, my lord, I think your lordships are suggesting my point. Inadvertently, my lord, though.
No, you are smart enough to take my point, not the complete.
My lord, 50 says power of taxation subject to the limitation imposed by Parliament by law. Now, this is the law. Now, that limitation is lifted for minor minerals. There is no, it can tax, my lord, for minor minerals.
So therefore, your argument is power of the state to levy taxes on operations regarding minor minerals is there. That power is not taken away.
Disputing that. It's
So-
nobody's case, my lord, that they don't have, and I'm saying that no, and they say that we have, and
So therefore,
we are on major minerals.
so states can levy taxes.
Of course, my lord, unless, my lord, it is prohibited. It is not prohibited. Tomorrow, Parliament can even prohibit. Logic, I mean, legally speaking. Not that
Can't
it
this
will.
logic apply even to major minerals?
Pardon?
Why can't this logic apply even to major minerals?
Lord, I am,
Then there is no distinction between the two.
Yes.
If your stand of the government of India is that
your lordships may not ask me that question. Lord, the answer is very simple. The entire act controls major mineral and keeps minor mineral out of it.
no.
Yes.
Section 4 is applicable to minor minerals also.
Correct, my lord. So, for the, what is section 4, my lord? What is
It
section?
says that without license or a lease, there can't be any mining operation.
Correct, my lord. And, my lord, kindly see, my lord, for 15, that what should be the nature of the lease, etc. The state will decide.
Yes, sir.
Yes, my lord, state. Your lordship, my lord, understood. I hope understood that, my lord, my proposition. That 4 provides that without lease and license, you will not, my lord. Kindly allow me to read your lordship, my lord. Said that I may not read, but I'll just read first section. Section 4. 1. No person shall undertake any reconnaissance, prospecting, or mining operations in any area except under and in accordance with the terms and conditions of a reconnaissance permit or prospecting license, or as the case may be of a mining lease granted under this act or the rules made thereunder. Now, this rule making power for minor mineral is 50.
Yes.
It's delegated power. That's all I'm saying. Now, my lord, please come to 25. Yes. Charges and the tax. To 18 title. Section 18 title. Development of minerals. Your lordships have seen first chapter regulation of minerals. Now development of minerals. Only section 18 I read. It shall be the duty of the central government to take all such steps as may be necessary for the conservation and systematic development of minerals in India. My power to fix uniform royalty flows from this. Systematic development of minerals in India and for the protection of environment by preventing or controlling any pollution which may be caused by prospecting or mining operations, and for such purposes, the central government may, by notification in the official gazette, make such rules as it may think fit. So then there are rule-making powers. Correct? Now please come to 25. Now I may read it closely, my lord. A little slowly, my lord. Recovery of certain sums as arrears of land revenue. Any rent, royalty, tax, or other sum due to the government under this act. Please mark the word under this act. The center has no taxing power under 54. So far as mines and minerals are concerned, state has no taxing power. It can be traced only under 97. This is a future contingency. If for some reason in future it is required to invoke 97, that is residuary entry, for the purpose of taxing mineral, because it is under this act. Initially the reaction would be that tax means tax imposed by the state government. No, it is tax imposed under this act. The rent, royalty, tax, fee or other sum due to the government under this act or the rules made thereunder or under the terms and conditions of any mineral concession may, on a certification of such officer as may be specified by the state government in this behalf by general or special order, be recovered in the same manner as in the land revenue. Lord, it provides whose taxation is the subject matter, the tax may be imposed under this act. And who will exercise the powers? Revenue officer. Why and whom? At whose behest? The state government. Because state in any case collects the royalty. There is no dispute about that fact. So, my lord, this again, my lord, show that tax, if at all, or royalty, etc., my lord, is the subject with, my lord, the central government. Now, your lordships may kindly come to mineral concession rules. So please come to Rule 31. No, page number is same. But maybe at page 65. Lord, I did not say, my lord, law relating to mineral development would include statutory law, including delegated legislation. The rules also, my lord, would be law for the purpose of, my lord, that entry. Please, my lord, your ladyship may see Rule 31. Now, my lord, after, my lord, showing the architecture, I am, my lord, trying to take your lordships closer to something very specific, my lord. 31. Lease to be executed within 6 months, where on an application for the grant of a mining lease, an order has been made for the grant of such lease. A lease deed in Form K, please mark this, my lord. Lord, Form K, my lord, is very, very crucial to answer your lordship's question, my lord, where it is all inclusive. Form K, or in a form as near thereto as circumstances of each case may require, shall be executed within 6 months of the order or within such further period. We are not concerned, my lord. If it doesn't not, then it lapses, my lord. We are not concerned. Now, please come to, my lord, Form K. I don't think, my lord, in my respectful submission, there can be anything clearer than this, my lord, now Form K. Which, my lord, some part Mr. Salve had shown, my lord, but I am showing something else other than what was shown, my lord. So this is also a part of the statutory scheme. This is a statutory form annexed to a statutory rule, which is a part of the law made for mineral development and regulation under entry 54. Lord, please come to page 122, my lord, possibly.
Yes.
In your lordship.
Which part of Form K?
K, Form K, my lord. Sometimes I wish, my lord, the lip reading could have been a course in the 5-year law.
But when they are choosing jury members, they have people observing the body language of the juries, potential juries, And depending upon how they are sitting, how they are sort of gesturing, you will say, all right, he is a jury to be selected for my part, in my turn.
Oh.
Just in a lighter vein, solicitor, if you are privy to all the conversation which is happening here for last 5 days,
I'll be
perhaps
discussing.
matter would have been over by now.
That secret keeps us going, my lord. Whether we it is only that secret, my lord, which all of us, my lord, that keeps us going, my lord.
There is still hope.
My lord, that was a very potent word, my lord. Almost, my lord, divulging what my Lord Justice spoke.
No, what I said applies to Mr. Dwivedi also.
Lord, I'll not, my lord, kindly, my lord, go through it. Go through, my lord, the entire parliamentary debate. What it says is that we cannot have a narrow state-wise understanding of the royalty regime. Whatever is to be done has to be done holistically, nationwide, and global-wise. So that was the intent and purpose. Now, my lord, I'll cite, my lord, two judgments. Now, well, it's the
Parliament may impose by law.
The word limitation starts with a taxing limitation. See the entry. I'm going ahead of my own story. Just see the entry. 50 says taxes on so and so, including limitations. The primary limitation has to be a taxing limitation. It is dealing with, in fact, 50 is a recognition of parliamentary superiority in taxation,
But in,
apart from other things.
but in HS Dillon, this
Yes.
court has said, if a taxation entry is absent in list 1 or list 2, then it can be entry.
That's exactly what Mahalakshmi says. That's exactly what 5 judgments of your lordship says.
But we have all seen from the last 2-3 weeks, we are seeing the taxation entry in entry 50.
Well, it's with respect. It's that private law example, very loose example, wrong example, but of Renvoi. It's a circle. Your lordship knows Renvoi in private international law. It's a circle. 50 you start with. 50 recognizes the superiority of parliament, especially in taxation. These last 3 words have been less emphasized. That superiority of parliament in taxation then gets completely coalesced and developed by a conjoint reading of 54 with 97. Because 50 subordinates itself in taxation, to a parliamentary taxation.
What entry 50 recognizes is that the taxes on mineral rights can be imposed only by the state legislature, since it's in the state list. But while doing so, you are subject to the limitation which Parliament may impose by law. That is not to say that the moment Parliament imposes a limitation, that whole field is then transferred as a taxing power to the union.
That is Mr. Salve's and Mr. Mehta's argument. I am now doing a totally different nuanced argument. That first part, your lordship, is totally occupied, etc. I am not delegating that well as if this succeed, if your lordship will hold this way, that matter ends, this way or that way. Now I am saying something in addition. That's why I said this is separate. One is occupation. Really does. That's fine. Actually, the rest of my written submission has those submissions. I'm not giving your lordship those submissions at all. My argument is that forget the occupation doctrine. Well, listen, may I do it when I come to the third proposition rather than do it now? Your lordship will read the entry itself and develop it from there. Let me just finish the propositions first. So that's my third proposition. And that is dealt with in para 8 to 32, pages 5 to 15. Which is corrected. Now, the fourth proposition is, of course, I must emphasize wholly in the alternative. Your lordship has been dealing till now with mineral rights. Ask a simple question, Maris. Regulation and mineral development is the word in 54. If they didn't want the words to be different, why did they use mineral rights in 50? The answer is also answered by a lordship. So all these cases have not been given meaning and importance by Wallace Kesharam. And many of them have been noticed, not only Justice Sinha, but in other judgments. Why is it that 50 uses mineral rights? Whereas 54 uses, if they wanted to give the entire space, the entire universe they would have used the same words as 54 in 50. Or they would have used the words of 23 in 50. 23 is a mirror image of 54, which is why your lordship has always held denudation. They use mineral rights because it's a very narrow area given. So my fourth submission is, your lordship should lay down in this judgment, because we don't come to 9 judges again and again. Lordship doesn't want chaos in the law. The difference between tax on minerals versus tax on mineral rights. The two are different. Your lordship will only lay down guidelines. The division benches will decide whether the impost in question falls this side or that side. But your lordship must lay down guidelines. Because, take a simple example, brothers. My lease or license to him of 10 years, 15 years, 100 years can be taxed. That's a tax on mineral rights. It is very different from taxing the quantum of mineral extracted on tonnage or sale. That is conceptually different. The language is different. The advisory, the constitution uses different language. Please don't equate tax on minerals with tax on mineral rights. That's my fourth proposition. Well, it's my fifth is, well, the alternative, which is again not been argued. It is a clarification which is important from 9 judges. That today we leave this court, Wallace, after arguing all this tax this way, tax that way. Tomorrow, Wallace, the states get up and say that was a case deciding tax. Oh, but I have the power to levy the same thing or similar things on the ground of fee. Now, your lordship is held very clearly.
We are just almost at 5 to 4 now.
Tomorrow.
We'll continue tomorrow.
I will
now,
finish well in time. Mr. Ganguly will get enough time.
Who follows Dr. Singhvi now?
Lord, I would, if your lordships permit, Lord, I would like to address for about an hour or so, if your lordships permit.
So, Mr. Kambata, then Mr.
After me, Mr. Ganguly is there.
Mr. Ganguly will argue. Mr. Bagaria.
No, I take 15 minutes, but there's a referral order.
We just
We'll all
want to put
finish
you.
tomorrow, Wallace.
Everyone has to finish by lunch. Dr. Singhvi will give you 10:30
3
to.
o'clock, make it. Mr. Devedi will get the full of Thursday and some part of tomorrow also.
Dr. Singhvi, what we'll do is this. We'll give you 10:30 to 11:15. We'll give Mr. Ganguly 11:15 to 11:45. Mr. Bagaria 11:45 to 12:15.
Can I say one?
Mr. Kambata 12:15 to 40 to 1 and 15 minutes for you.
Well,
That's
only
it.
one thing.
Everybody else, you are not.
Your lordship has seen the nature. Allow me at least 1 hour, but it won't be fair otherwise. On the submissions.
I was wanting 10 minutes, Lord.
Dalmia's been order by a 3-judge bench, where they referred 6 questions and directed it to be tagged along with this. Now, my lord, my submission is I'm going to request your lordship. Those out of the 6, only 1 relates to nature of royalty. The remaining 5 can be kept separately. Subsoil right, who owns the minerals, etc. That's so I have made a PowerPoint presentation, and I'll just take 8 to 10 minutes, about 6 slides I have to show your lordship. If your lordship,
So you want that to be detagged there?
I have to make
Except
submission
on royalty.
The royalty issue.
On
Remaining
royalty.
I'm not submitting. I made, and to save time, I made a
I think that should be detagged, Lord. That should be detagged.
No,
I have a similar request.
subsoil
For
can be
ONGC and other,
ONGC also got detag, yeah.
ONGC
So
oil,
you can tell us which are the matters to be detagged. I think on this issue we don't
tomorrow.
dispute. Mr. Dwivedi, Mr. Datar and the Learned Solicitor General. Please give the courtmaster by tomorrow morning the list of matters which are to be detagged. Mr. Datar, we will detag your matter as well on royalty. Since we have heard arguments on what is the nature of royalty,
I had only
we can take a
submitted
small
on entry
note.
50. I've just submitted on entry 50 as to what is this, and I've made this submission. I've said that the levy, entry 50 talks of tax on mineral rights. Tax has 3 components: levy, assessment, collection. Levy is taken away by 99A90, so I've made a chart. Only levy is taken.
Give us a chart.
Lordship may just.
But we have given you
Your
the
Lordship
bottom,
has-
1 second, we have given you the bottom line. All learned counsel have to put their heads together so that you finish by lunch tomorrow. Absolutely no question of going ad nauseum. We will never finish otherwise. This will go on to next week and we have another matter next week.
May I just say one thing?
The other submission we have made in the context of mining lease. Not mining lease is normally for a particular area, 20 square kilometers, 40 square kilometers. So we have drawn a map. Tamil Nadu both is entry 49.
All right, we'll de-link your matter, Mr. Datta.
No. Mine only on royalty. Mining lease is only entry. The mining
Given
lease.
the royalty, we'll hear you in we'll give you 5 minutes to hear your arguments on royalty. We have heard
This is going to be some moment. We will not be able to do justice.
My lord, I just wanted.
I'll cut 1 hour from my argument. Allow me till 11:45. Mr. Datta, Mr.
we have no difficulty. We have no difficulty. Anybody who feels that, everybody has to decide now that, who's going to take how much time.
I'll finish by 11.
But no difficulties.
My lord,
I'll get to complete it after.
Till 4 o'clock.
This side will know. Sorry, we'll not do that.
my lord, I was wanting 5 minutes.
Whoever remains written submissions, Mr. Dwivedi, you start at 2 o'clock and you conclude at 4 o'clock.
My lord, maybe we have 5 minutes, my lord.
I will take Thursday. Give us Thursday, brothers. We will not go beyond Thursday, brothers.
Your lordship gave me
My lord,
your lordship gave me 1 day.
The matter will be ultra lordship.
My lord,
A huge plot. But it will not, so but it's going to affect all mineral rights.
adding zeros doesn't change the legal principle. The principle is always the same. Irrespective of the number of zeros or decimal places added.
my lord, please.
But I was wanting 5
Point मैं आपको हिंदी में समझा सकता हूँ. आप सब शाम को बैठ लीजिए, तय कर लीजिए. 2 घंटे में, 2.5 घंटे में सुबह आपको सबको तय करना है. इस बहस इस तरफ. 2 o'clock we are putting Mr. Dwivedi in. This will never get over otherwise. Thank you.
Good.